We've all heard the ads on the radio and seen them on TV where an attorney tells potential clients, if we don't recover for you, you don't pay a dime. Hi, my name is Peter Lamont, and I'm a business and personal law attorney practicing here in the state of New Jersey. Now, those advertisements can tend to mislead people because there's a distinction between not paying an attorney's fee versus paying for expenses on the file. And I want to explain this to you so that you have a better understanding. And when you see those commercials, you understand that it's not all as straightforward as they make it seem. So when an attorney decides to take a case on a contingency basis, that means essentially that they will take a percentage of whatever they recover for you. And if they don't recover, then they're not entitled to attorney's fees. But what's missing in those commercials is the fact that attorneys, when cases are filed and started, they have to lay out money to cover the expenses associated with the file. So for example, if they're going to file a complaint, that's a couple $100s that they have to lay out. If there's going to be a motion filing, that could be $35 or so. Depositions, expert witnesses, expert reports. It adds up, and it can be a significant amount of money at the end of the day. And attorneys should tell you when you sign a retainer with them on a contingency case whether or not they intend on collecting from you the expenses. So you need to be cognizant of the fact that when you go in and you meet with a lawyer on a contingency case, ask them who pays the expenses. If they're not forthcoming with that information, then they're probably not your best choice. You need to have a full understanding of what you would be responsible to pay in the event that you do not recover anything from the lawsuit. Now, other times, an attorney will cover the expenses for you, and they'll advise you of that fact, and they'll tell you you're not responsible for anything. That needs to be in writing somewhere in your retainer that the attorney is not going to, at any time, seek to collect reimbursement of expenses from you on a contingency case. Now, in the event that you recover and you're successful in your claim, oftentimes the expenses that the attorney lays out, they come off the top of the settlement amount. So if the expenses were $100 in a file and you received $500 in a settlement, the $100 would come off first, so 500 minus the 100, leaving 400. Then the attorney would take his percentage, and then you would be left with the rest. The purpose of me telling you this is to clarify some of the misleading advertisements that you might encounter concerning contingency fees and what your actual obligations as a client are. If you would like more information about this topic, or you'd like to ask us questions about how we represent clients on a contingency basis and what our policies are concerning reimbursement of fees, I'd be happy to speak with you. You can reach me at 973-949-3770 or via email at plamont@peterlamontesq.com. I answer questions like this and on other legal matters on a daily basis, and I'd be happy to speak with you. So I encourage you to pick up the phone and give us a call. Thank you.